my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy and the right to be forgotten. The right to be forgotten figures prominently in data privacy laws like the GDPR in Europe, and as well as the national data privacy laws in Canada. So the idea behind the right to be forgotten is that a person under certain circumstances can ask for companies to delete data about them. And the right to be forgotten has been probably one of the toughest things that companies had to deal with in terms of trying to comply with different data privacy laws. Recently, there's a very interesting case out of Canada related to the right to be forgotten, and this relates to Google and how search engines gather information. So, in general, if someone wants a search engine to take something down about them that's negative in some way, they can make a request to the search engine, and typically they'll ask, the reasons why you want to take the thing down. But for the most part, search engines will direct people, and even rightly so, to contact the original publisher of the information, because search engines really are supposed to be an index of information on the internet. It's not the internet. But in this particular case in Canada, there was a gentleman who wanted Google to delete search links, or the fact that he could search for his name on Google and there were results that were prominently featured that were negative about him. They were negative in the way and caused harm to him because some of those things were about his sexual orientation and serious medical issues, where he thought that he was discriminated against in terms of employment, and also was assaulted actually as a result of these search results showing up prominently in Google. The Privacy Commission in Canada ruled in his favor, saying that Google should take down these particular search results about this individual, basically delinking it in the search engine to make it harder for people to find it. So Google isn't the only search engine, but currently Google has about 75% of the world market in terms of search. So most people who do searches do so on Google, but I think that this particular ruling will have far-ranging implications for other search engines and how they gather information about individuals, and also having takedown requests that are made of individuals about negative or defamatory things that are actually on search engines. So this is an interesting case. I want to look very closely at other cases that come up. I call these almost like David and Goliath cases, where a lot of people don't think that the little guy is going to prevail, but they do in certain circumstances. Another reason why it's interesting is because a lot of social media companies or companies that serve up information consider themselves intermediaries, where they're just publishing what's existing. They're not really the content creator, and they're not the publisher, not considered a publisher like a newspaper would sort of curate content and things like that. So this particular ruling is very significant, and I think it will have far-ranging implications for not only search engines, but actually the role of intermediary companies when they deal with data of individuals. That's it. Thank you.